Well, good evening, everyone, and welcome back to AJ 101 Online. My name is Tony Farrar, and I am your instructor for this semester. Now, tonight's lecture is going to be on Chapter 14, covering punishment and sentencing. And before I get going, I just want to take note that on page 466 and 467 is a very interesting case study, if you will, that I would really like you to read and to think about as we talk about a few of these things that we're going to discuss in this chapter, because we're going to look at punishment rationales and what are some constitutional limitations and criminal sanctions, what should sentencing be, plea bargaining, sentence enhancements, and even capital punishment. So if you could read this intro before you really listen to the lecture, I think that would be great context as we go through this particular lecture this evening. But with that being said, let's go ahead and jump into chapter 14. So this lecture is going to pretty much describe the purpose of criminal punishment and the sentencing of offenders. Now, sentencing, as we know, is the last stage of a criminal trial, and it can be defined as the process through which a sentencing authority imposes a lawful punishment or other sanction on a person convicted of violating a criminal law. Now, the great author C.S. Lewis, writing about the justice system, once wrote these words: "It is only as deserved or undeserved that a sentence can be just or unjust." And I would ask you to think about those words as you read the remaining portion of that introduction, that case study, and also as I jump into this particular very quick case study. And again, it's not going to take very long, but it's going to help add context. So we have a couple of cases that we're going to look at. And the first one, I'm going to be brief, is on Brock Turner. And this is a sexual assault and rape case where a very, very well-known swimmer from Stanford University basically raped an unconscious woman behind a dumpster at a party. Now, at the end of this whole thing, and the reason I don't have a lot of content up here is because I want you to kind of look it up yourself, these two cases, and think about them. But at the end of the entire trial process, when everything washed out, Brock Turner was sentenced to 6 months in jail. And there were several witnesses and a lot of evidence to show that he did what he did. And think about this. He was convicted by a jury on 3 felony counts of sexual assault. However, he was only sentenced to 6 months in jail. On the other hand, we have the Corey Beatty sexual assault case, the case of the Vanderbilt football player. And his case was somewhat similar, not exactly, but somewhat similar. And he was found guilty by a jury, but yet he was sentenced to 15 years. And the question I ask you is, how do the differences come about in these two sentences? What made these two cases different and why? And I want you to take the time to look at these two cases. If you use any search engine and you put the information in there, you'll be able to find some information on both of these and try to solve the question as to why there are some differences in these two particular cases. So let's talk about punishment and sentencing. Now, one fundamental way of distinguishing crimes from their civil law counterparts, which are torts, and we've learned that, is to recognize that crimes are subject to punishment. as one legal scholar said, the best candidate for a conceptual proposition about the criminal law is that the infliction of punishment is sufficient to render a legal process criminal in nature. Now, noted legal scholar and professor at Columbia University College of Law, George Fletcher, noted, as a test for when processes are criminal, the Supreme Court unhesitatingly invokes the concept of punishment as the relevant criterion. So, hence, regardless of the classification given to a statute by legislature, criminal, civil, or administrative, if punishment is associated with the violation of the law, the U.S. Supreme Court has ruled that constitutional guarantees of due process must apply. So the purpose of punishment under criminal law is based on the just deserts model of criminal sentencing. And it holds that criminal offenders deserve the punishment they receive at the hands of the state, and suggests that punishment should be appropriate to the type and severity of the crime. Now, the need to assign blame and the need to punish wrongdoers may be fundamental human qualities. Criminal law itself may be rooted in deep moral and psychological principles basic to the human way of life. And within this context, it is important to realize that punishment as a mechanism of the criminal law can be distinguished from other attempts to discourage undesirable conduct, such as taxes or licensing requirements or civil liability or other administrative regulations. Now, well-known legal philosopher H.L.A. Hart identifies 5 distinguishing features of criminal punishment that set it apart from other sanctions. Now, this is going to be different than the 5 primary punishment rationales that operate in our society. So hang with me for a minute. So back to the other one. These are 5 distinguishing features of criminal punishment that set it apart from other sanctions. First, it must involve pain or other consequences normally considered unpleasant. Second, it must be for an offense against legal rules. Third, it must be imposed against an actual or supposed offender for his offense or her offense. 4, it must be intentionally administered by human beings other than the offender. And last, it must be imposed and administered by an authority constituted by a legal system against which the offense is committed. Now, more important perhaps than any definition of punishment is the purpose of punishment under criminal law. Now, Lewis's notion of punishment as deserved, alluded to at the start of this lecture, underlies the purpose of most criminal punishment and supports what today is called the just deserts philosophy. And I kind of went over that a second ago if we go back here and we talk about the just deserts. And just deserts is a popular model of criminal sentencing that holds that criminal offenders deserve the punishment they receive at the hands of the state, and suggests that punishment should be appropriate to the type and severity of the crime. And although at first glance the just deserts philosophy may appeal to common sense, it is important to realize that punishment is not the only goal of sentencing, because in fact There are 5 primary punishment rationales that operate in American criminal justice today, and that's what we're going to talk about right now. And the 5 are retribution, deterrence, rehabilitation, restoration, and incapacitation. And we'll discuss each briefly. So the first one is retribution. Now, one goal of criminal sentencing is retribution, and retribution is the most punishment, if you will, oriented of all the sentencing goals, and really underlies the just desserts philosophy. And as one writer observes, the distinct aspect of retributivism is that the moral desert of an offender is a sufficient reason to punish him or her. And retributivism is a very straightforward theory of punishment. And we are justified in punishing because only because offenders deserve it. Still, retribution may call for even harsher punishment than those that are merely deserved. Now, the purpose of retribution is to basically get back at the offender by meting out a punishment that is in some primal way satisfying to the social group and to the victim of his or her survivors. So, again, it's the most punishment-oriented of them all. It follows along that just desserts philosophy. And it is an act of kind of taking revenge, if you will, on a criminal suspect. And it claims that we are in fact justified in punishing offenders. You know why? Because they did what they did, and because they did it, they deserve it. So the purpose, again, is to get back at the offender by dishing out, if you will, punishment that is in some primal way satisfying to the social group. Everybody thinks it's okay, it's agreeable, and to the victim of his or her survivors. So the central idea behind retribution is recognition of the fact that it holds offenders responsible for their behavior and supports the view that the law violators freely choose their illegal courses of action. Well, what about deterrence? So this is the second of them. So a second goal of criminal sentencing is something that we call deterrence. And deterrence, like retribution, also depends on the imposition of punishment, although kind of in a different purpose. Under the philosophy of deterrence, punishment is seen as an inhibitor, if you will, capable of keeping behavior in line. Now, there are 2 types of deterrence, specific and general. Specific deterrence is intended to deter the individual sentenced to punishment from committing future offenses. So a burglar sentenced to a number of years in prison, for example, may find the lack of freedom so painful, or such a painful experience, that he or she basically is going to refrain from committing any new crimes once they get out. The punishment was so bad, dude, I'm just not going to do it again. Now, general deterrence, on the other hand, uses punishment as an example to others who may be contemplating breaking the law. Hence, the burglar sentenced to prison stands as an example, if you will, to associates that they too may face a similar fate if they choose that type of action. So that's the difference here between specific and general. Now, critics of deterrence say that there is little evidence that punishment deters criminal behavior. In fact, say critics, many criminals seem to commit one offense after another, a fact that calls into question the efficacy of deterrence as a sentencing philosophy. Now, other writers disagree. And they say it like this: if I interview 1,000 prisoners, I collect information about 1,000 men in whose cases general prevention has failed, but I cannot infer from this data that the general prevention is ineffective in the cases of all those who committed the crimes. In other words, although deterrent effects may be difficult to measure, that doesn't mean that they don't work or that they don't exist. Now think about this before I move on. We already know there's a punishment for murder, but yet people still murder. So, I mean, how does that fit into the whole deterrence thing? So again, under deterrence, the severity of punishment may also be important as a deterrent effect, but severe punishments may be more significant deterrents of minor offenses than major ones. And probably the reason for that, well, I'm not going to kind of try to figure out the reason for that. Let's just go ahead and move on to onto the next one. Let's talk about rehabilitation. So we're on number 3. Rehabilitation, also a goal of criminal sentencing, is quite different in its purpose than retribution or deterrence. The purpose of rehabilitation is to reform criminal offenders, and ask yourself, can they reform? Sure, some can and maybe some can't. Restoring them to productive lives within the community. Now, rehabilitation programs, which may also include a punishment component, often involve job or skills training, educational coursework leading to high school completion, counseling, and even psychological treatment. So from the point of view of rehabilitation, the nature of the criminal offense is really less significant than the supposed likelihood of reforming the offender. Now, except insofar as the offense committed provides a clue to the need for specific rehabilitative strategies. So what is rehabilitation, what does the term kind of mean? Since we kind of know what the purpose is, we'll stay there. But the term rehabilitation, although widely used, may be something of a misnomer. It literally means to return a person or thing to a former state. A criminal offender's former state may, of course, not have been a desirable one, right? From one point of view, from those stressing rehabilitation. And many offenders grew up in a crime-prone area or even home, and may have been basically exposed early in life with values that easily led to law-violating behavior. Perhaps a better term here for what advocates say should be rehabilitation might be resocialization, a word that is sometimes interchangeable or associated with the process of rehabilitation. So again, the purpose of rehabilitation is to reform criminal offenders, restoring them to productive lives within the community. And the next one is going to be restoration. Now, restoration, the fourth goal of criminal sentencing, emphasizes the emotional and financial cost of crime to its victims, and really seeks to restore crime victims to a state akin to that which they were before they were victimized. Now, restoration is a sentencing goal that seeks to make victims and the community whole again, because we know that with these major types of crimes, even the community itself can suffer or have fear of crime. So this restoration, it frequently builds on the use of fines, restitution, and community service, forms of punishment that may be imposed on offenders by the sentencing authority or judge. Court-ordered restitution requires convicted offenders to repay their victims through an agency of the court, such as the court clerk. And restitution payments like fines may be collected on an installment basis, etc., by the court. And then, although restoration has been a goal of sentencing for many years, emphasis today is on the notion of something called restorative justice, and I think we talked about that in the last chapter. It's a concept that identifies a triad of needs, so like three. The need to compensate victims, the need to place appropriate responsibility on the offender, and the need to attempt to reintegration of the offender with the community. So an interesting model, and if you want to Google it or something, you can find a little bit more information on it. This whole restorative justice type of thing, again, it's a new dynamic and kind of interesting. So again, we already talked about the emphasis of restoration and also on restorative justice, so we can go ahead and move on. And when you look at restoration, I have a little diagram in here that you can kind of take a peek at, and this is the triad again, dealing with community, victim, and offender, and accountability, safety, and development. So that's kind of how it's played out. So that brings us to our final sentencing philosophy. And this can be found in what most of us think is what should be done, but of course not all of us. Now, California, actually the United States, leads the way when it comes to putting people in jail. And this is incapacitation. So incapacitation is a strategy that makes use of imprisonment or some other sentencing option to reduce the likelihood that an offender will be capable of committing future offenses. And it kind of makes sense, right? If they're in jail, yeah, they can commit some crimes, I suppose, in jail or prison, but they're not out in your community pillaging and robbing and doing things like that. Now, that's just one thought on the theory of incapacitation. Now, as one writer says it, incapacitation is founded on the basic premise that those who are removed from a community, specifically through incarceration, can't victimize society during a time of physical separation, meaning like while they're in jail, it doesn't matter. They can't do anything. And while that seems like an extremely simple solution, we already know, based on California with prisoner overcrowding, and AB 109 and all those other types of things, that it doesn't always work just to put everybody in jail. Now, during the 1980s, the prisons throughout the United States were basically warehouses for huge numbers of prisoners that judges and paroling authorities were reluctant to release into nation streets. And we kind of understand that, but the trend towards warehousing, which continues a little bit today, can be seen in three strikes legislation, which mandates long prison sentences for offenders who are convicted for a third felony offense. And as a sentencing strategy, incapacitation works best when it incapacitates those who are most likely to commit repeat offenses. And if you look in your book, there's a couple of terms in there, and one of them is habitual offender, and the other is career offender. So let me define those very quickly for you before we kind of move on, and I will talk a little bit really quick on the three strikes thing. So a habitual offender is a person sentenced under provisions of a statute declaring that those who are convicted of a given offense are shown to have previously been convicted of another specified offense or offenses shall receive a more severe penalty than that for the current offense alone. And a career offender is defined as, under federal sentencing guidelines, a person who is 1, at least 18 years old at the time of the most recent offense, 2, is convicted of a felony that is either a crime of violence or controlled substance offense, and 3, has at least 2 prior felony convictions of either a crime of violence or a controlled substance offense. And the 3 strikes thing, that's a statutory provision that mandates a lengthy prison term for criminal offenders convicted of a third violent crime or felony. Now, just really quick, California has one of the nation's toughest 3 strikes laws, requiring life sentences for 3-time losers, if you will. And shortly after the passage, however, California 3 strikes law was called into question by a California Supreme Court ruling which held that judges could disregard prior convictions at sentencing when they believed that a mandatory life in prison sentence would be unwarranted. Now, in 1997, however, the California Supreme Court ruled that a 3 strikes defendant could be punished under the law for past juvenile convictions for violent offenses. Specifically, the court held that prior adjudication of a delinquent offender 16 years of age or older for an offense that would count as a strike if it were the result of an adult conviction could count as a strike once that person attained adult status. Now, in further refinements to the applicability of the state's 3 strikes law, the Supreme Court, the California Supreme Court ruled in 1998 that a single criminal act involving multiple charges could count as more than 1 felony offense for purposes of law. Also in 1998, the state Supreme Court put limits on judges' discretion in exempting repeat offenders from receiving lengthy sentences under the 3 strikes law. And the court ruled that a defendant whose past and present conduct showed him or her to be within the spirit of the 3 strikes law must be given the full sentence required by the statute. Now, a year later, the U.S. Supreme Court refused to hear the case of Michael Wayne Riggs, who was caught stealing vitamin pills from a California supermarket and was sentenced to 25 years in prison based on a record of drug crimes, robbery, and other felonies. And many saw the court's refusal to hear the case as an endorsement of California 3 strikes laws. Now, on March 7, 2000, California voters passed Prop 21, which broadened legal categories for determining what felonies can count under that state's 3 strikes laws. And as a result of that change, violent and serious felonies now officially include gang-related felonies and conspiracies under California law. Now, finally, supporters of 3 strikes laws argue that they lower crime rates by ensuring that those convicted under them are denied the opportunity to continue their criminal careers. So there were a couple other cases in 2003, but I'm going to go ahead and stop there, and that was just a little bit of information on the 3 strikes laws. Now, back to constitutional limitations. Well, there are several constitutional provisions, if you will, that come into play during sentencing and punishment. For example, you're going to learn pretty quick that the Sixth Amendment right to a jury trial has significantly affected sentencing procedure in recent years. Now, of course, due process is omnipresent, providing a safety net of fairness, but most of the significant provisions in the Constitution in regard to sentencing and punishment are found in the Eighth Amendment, which reads as follows. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. And there are 3 clauses in the 8th Amendment, the prohibition, if you will, of cruel and unusual punishment, again, the prohibition of excessive fines, and the prohibition of excessive bail. And a lot of times these death penalty cases and even life imprisonment cases are ones that are brought up under the 8th Amendment. So when we talk a little bit more about constitutional limitations, the Supreme Court has held that the concept of cruelty is changing, reflecting more contemporary, if you will, standards of decency. And there has been an explosion in 8th Amendment jurisprudence or law, if you will, in recent decades. Now, today, inmates enjoy protections that were really never imagined by the framers of the Constitution, including the right to medical care, a minimum amount of space. Who would have thought of that? Exercise or physical activity, a healthy diet, and access to legal materials, among other things. And I have a couple of different photos of different cells. You know, the old-fashioned ones are kind of on the bottom, and then at the top you can see a more clean and I would suppose more dignified type cells. But these limitations, again, have changed over the years. And there are some prisons and jails that even have a more bougie, I guess is a good word, or refined or better looking cells and access to more types of things like TV and even internet. So who would have thought? Now, part of part of this chapter needs to kind of lean towards, we know what sentencing is, and we've talked about some limitations. Well, let's talk now about imposing criminal sanctions. Now, at the beginning of this lecture, I said that sentencing is the process through which a sentencing authority imposes a lawful punishment or other sanction on a person convicted of violating the criminal law. Now, in almost all cases, the sentencing authority is a judge, although in some jurisdictions and for certain crimes, juries may be called on to recommend an appropriate sentence. Now, until recently, judges in most U.S. jurisdictions had considerably more leeway in sentencing decisions than they do today. Now, as little as 30 years ago, most jurisdictions in the United States followed the practice of what we call indeterminate sentencing. And an indeterminate sentence is a type of sentence to imprisonment in which the confinement, instead of being for a specified single time period or quantity, such as 3 years, it's more for like a time range, such as 2 to 5 years, or 5 years maximum and 0 minimum. Like other sentences, indeterminate sentences for a multiple of offenses could be imposed either either concurrently or consecutively. And a consecutive sentence is one of 2 or more sentences imposed at the same time after conviction for more than one offense, and which is served in sequence with the other sentences. That is, consecutive sentences are served one after the other. Now, conversely, a concurrent sentence is one that is served at the same time another sentence is being served. So one is just one after another, and one is at the same time. Does that make sense? So we have consecutive and concurrent. But now let me get back to indeterminate. So indeterminate sentences were the rule throughout most of the United States for well over 100 years, they were imposed in the belief that an offender facing a flexible sentence would be motivated to earn an early release from confinement through good behavior. And under the indeterminate model, the inmate's behavior while incarcerated is the primary determinant of the amount of time he served. Hence, inherent in indeterminate sentencing strategies is the hope of rehabilitation through self-motivation, right? Well, a disappointment with the rehabilitative ideal kind of grew. However, many states and the federal government increasingly switched to determinate sentencing approaches. So in 1978, California joined the determinate sentencing bandwagon, so everything switched now with passage of the California Determinate Sentencing Act. So again, we have indeterminate sentencing and we have determinate sentencing. And you can basically kind of see the difference between the two. And I'm going to talk a little bit more about determinate. So we already know what the indeterminate sentencing is by review. Again, they're imposed with the belief that somebody facing a flexible sentence would basically be good and try to earn their way out. Well, now let's look at determinate. So a determinate sentence sets a single standard or time quantity of imprisonment. In determinate sentencing, jurisdictions, judges, have little leeway in imposing sentences. And criminal law violators are sentenced basically to predetermined punishments generally set by law. The California law, for example, allows judges to impose a short, average, or long sentence for each offense of which the defendant is convicted. Now, judges must, however, impose the average length sentence unless there are some type of extenuating circumstances, and they must indicate that either the shorter or longer sentence is more appropriate. Now, any deviation from that standard requires the judge to explain in writing and for the record why there was a deviation made. So imposition of a long sentence would require judges in California to actually hold a formal fact-finding hearing before the sentence is passed. Now, another reason for the growth of determinate sentencing schemes, which are also termed fixed or mandatory or structured, was a perceived need to ensure three fundamental sentencing principles, and that's proportionality, equity, and social debt. And we'll take a look at that in a minute. So again, one of the reasons for having a fixed sentence, or something that if you do this, here's the punishment, is to make sure that we are addressing these three principles of proportionality, equity, and social debt. Now, proportionality refers to the belief that the severity of sanctions should bear a direct relationship to the seriousness of the crime. And under the principle of proportionality, offenders committing similar crimes should receive similar sentences. And that kind of makes sense. Now, under indeterminate sentencing, two offenders who commit similar offenses could actually, and probably would, see different judges and could actually receive different sentences. So you can see how this proportionality comes into play relating to criminal sanctions. Well, what about equity? Well, equity is based on a concern with social equity and means that similar crimes, again, should be punished with the same degree of severity regardless of the social or personal characteristics of the offenders. And then finally, at the end, talking about social debt, this is the sentencing principle that objectively counts an offender's criminal history in sentencing decisions. So through the Sentencing Fairness Act of 2010, Congress and President Obama addressed this particular problem of determinate and indeterminate sentencing, if you will, by changing the relative punishments for quantities of each. And finally, the principle of social debt, which counts an offender's criminal history in sentencing decisions, should be objectively recognized in any sentencing decision. And there are factors a lot of times that will determine these criminal sanctions. So determinate sentencing incorporates, again, the principles of proportionality, equity, and social debt by standardizing the sentences according to the offense severity and criminal history. In determinate sentencing jurisdictions, judicial deviation from determinate sentencing standards, although possible, typically must be predicated on the finding by a judge of specific, what they call aggravating or mitigating factors that are laid out or written down or enumerated by the sentencing laws. Now, mitigating factors, these are circumstances surrounding the commission of a crime which do not in law justify or excuse the act, but which in fairness may be considered to reduce blame. And aggravating factors are circumstances relating to the commission of a crime which cause its gravity to be greater than that of the average instance of the given type of offense. So the question I would throw out there, are these good things? Should a judge be able to take into consideration aggravating or mitigating factors? Is there a difference between a homicide, let's say between a husband and a wife based on some argument or what have you, and someone that breaks into a house and sexually assaults somebody and cuts them up into pieces and puts them in a freezer? And I know that's kind of a really nasty example, but are there aggravating factors to that particular murder? So think about that as we continue on with our discussion. Well, we talked a lot about state guidelines and a couple of federal, but what about criminal sanctions under federal sentencing guidelines? Well, the movement towards determinate sentencing was really led by the federal government, which in 1984 passed the Sentencing Reform Act. And the act was established by the U.S. Sentencing Commission under the leadership of Judge William Wilkins Jr. and mandated the development of determinate sentencing guidelines. Now, guidelines developed by the commission took effect on November 1st, 1987, and combined the seriousness of an offense with an offender's past criminal record in computing or adding up the length of prison time to which a federal court should sentence a convicted offender. Now, federal sentencing guidelines are built around a table containing 43 rows, basically, each corresponding to one offense level. And the penalties associated with each level overlap those levels above and below in order to discourage unnecessary litigation. So it kind of looks like this. So although, again, based on determinate principles, current federal sentencing practices continue to reflect the traditional goals of sentencing, but you can see you have the offense level and the type, and it's almost like a chart. You can go like this, and this is the penalty. Does that kind of make sense? But this is what they call the sentencing table. And again, on the left is the offense level, and across the top is the criminal history category. Now, what's the role of the jury? Because we talked a little bit about this, and it is really important that we understand the role of the jury here. So in In a 2013 case, Allien versus United States, the U.S. Supreme Court overruled an earlier case and found that any fact required to increase a sentence must be found by a jury, not a judge. So kind of an interesting case that came about here when we're talking about the role of the jury in sentencing. So again, in 2000, the U.S. Supreme Court, well, let me go back. Before this case, in 2000, in the U.S. Supreme Court case of Apprendi versus New Jersey, the court questioned the fact-finding authority of judges in making sentencing decisions, ruling that other than the fact of a prior conviction, any fact that increases the penalty for a crime beyond the prescribed statutory maximum is, in effect, an element of the crime that must be submitted to a jury and proved beyond a reasonable doubt. Now, in 2013, again, we had that case of Allien versus United States, where the U.S. Supreme Court overruled an earlier case and found that any fact required to increase a sentence must be found by a jury, not a judge. So again, a couple of interesting things. Now, in two cases in 2005, the U.S. Supreme Court greatly expanded judicial discretion at the federal level when it declared federal sentencing guidelines advisory rather than mandatory. And the court found that federal sentencing guidelines unconstitutionally forced judges to increase sentences based on their own factual findings rather than those of a jury. So a couple of cases to talk about there. Just a few more minutes left and we're getting close. Plea bargaining. So many sentences are imposed as a result of bargained pleas. That is, as the result of basically agreements between the prosecutor, defense attorney, and the court as to what an appropriate sentence might be for an offender who pleads guilty. Now, for a plea bargaining, again, you have to plead guilty. You can't plead not guilty and take a plea bargain. Now, fully 80 to 90% of sentences in some jurisdictions result from plea bargaining. And in a study of 37 big city prosecutors, the Bureau of Justice Statistics found that for every 100 adults arrested for a felony charge, half were eventually convicted of either a felony or misdemeanor. And of all those convictions, 94% were in fact the result of a plea bargain. And only 6% were the result of an actual trial. Now, plea bargaining circumvents the trial process and dramatically reduces the time required for the resolution of a case. So there is a need for it. Imagine if every case had to go to trial. So as such, it greatly increases the number of criminal cases that can be processed by a court. Without plea bargaining, most criminal courts would become just mired, if you will, in the legal formalities required by trials, and case backlogs would increase substantially. So it really is something that is necessary. So along with plea bargaining and other sentencing strategy, there are some what we call traditional sentencing options, and these are the recognized options that we're going to talk about. So sentencing is fundamentally a risk management strategy almost designed to protect the public while serving the ends of rehabilitation, deterrence, retribution, and restoration. So it's the end, it's the sentencing part. And because the goals of sentencing are difficult to agree on, so too are sanctions. And lengthy prison terms really do little for rehabilitation, because who are they in there with? Other criminals, usually. And community release programs can hardly protect the innocent from offenders just bent on continuing their criminal ways. Assorted sentencing philosophies continue to permeate state-level judicial systems, and each state has its own sentencing laws and frequent revisions of those statutes that are not uncommon. So because of huge variations from one state to another in the laws and procedures that control the imposition of criminal sanctions, sentencing has really been called the most diversified part of the nation's criminal justice process. Now, there is at least one common ground, however: the four traditional sanctions that continue to dominate the thinking of most legislators and judges when dealing with criminal law. And these four traditional standards are imprisonment, probation, fines, and death. Now, because we don't have a lot of time, I'm not going to spend a lot of time on each, and I'm just going to touch on each one just quickly. So, imprisonment, probation, fines, and death. Now, we know what imprisonment is, we know what fines are, and we know what death is, so I'm going to kind of jump to probation here really quick. Now, probation is a sentence of imprisonment that is basically suspended, or it's deferred. It's granted through a judgment suspending the prison sentence imposed on a convicted offender, and the offender's continued freedom is conditioned on his or her meeting certain behavioral requirements, such as avoiding future law enforcement violations. And probationers might be closely monitored or not, and often the conditions of probation are used to restore the offender to the community and to accomplish other rehabilitative processes. So again, often there are these things called conditions of probation that are used to restore the offender, but they also benefit law enforcement in a sense that part of your conditions of probation could be to take a drug test every 2 or 3 weeks or monthly. It could be to check into your probation officer. It could be to get employment. It could be to submit to any law enforcement officer at any time, search and seizure. So probation, has some value here. And although the number of active sentences handed out to felons may seem low to some, the number of criminal defendants receiving active prison time has increased dramatically over time. And when viewed historically, statistics reveal that court-ordered prison commitments have increased nearly 8-fold in the past 30 years. So that's one of the reasons for some other types of sentencing other than perhaps traditional. So here are some less traditional ones. So the list of less traditional sentencing options is kind of unlimited, really. There are a lot of things that can happen there. And the Eighth Amendment's cruel and unusual punishment clause, as well as statutory and administrative law, limits the punishments that may be imposed. And most less traditional punishments involve a physical component, perhaps pain or discomfort. Now some states have habitual offender laws, and some also have what we call hate crime laws. And we know what a habitual offender is. Again, this is an enhancement. A habitual offender or career criminal is a person convicted of a new crime who was previously convicted of crimes. And hate crimes under enhancement, Those are criminal offenses in which the defendant's conduct was motivated by hatred, bias, or prejudice, or based on actual or perceived race, color, religion, national origin, ethnicity, gender, or sexual orientation of another individual or group of individuals. And then, of course, we have capital punishment, the imposition of a death sentence. And today, 32 states and the federal government continue to employ capital punishment. And as of 2014, and I know it's a little outdated, 35 people have been executed in the United States. Now, we're not going to go into the debate here, but limits on death row appeals. The federal Constitution allows people who are in custody to challenge the legality of their confinement by seeking, remember, that writ of habeas corpus. Why am I being held? So these are things that can happen as part of the capital punishment process. Now, if you are sentenced to a capital punishment crime and the punishment is death, automatically it's something that's going to end up being reviewed at the highest level. Now, we already know what habeas corpus means because we've talked about that. Again, it's the Latin term that means you have the body, and a writ of habeas corpus is an order requiring a prisoner to be brought before the court to determine the legality of their detention. Now, in any petition beyond the first, filed with a federal court, capital defendants must demonstrate good cause why the claim is now being made and wasn't included in the first filing, and how the absence of that claim may have harmed the petitioner's ability to mount an effective defense. Now, death as cruel and unusual, there is much debate as to the constitutionality of methods for imposition of capital punishment. Today, lethal injection is the primary method of executing offenders in the United States, although there still are the punishment of firing squad. There are punishments of hanging. There are punishments of the gas chamber and even the electric chair, if you will. But really today, lethal injection is the primary method of executing offenders in the U.S. And the court has held, for example, also that a person may not be executed for crimes committed when they are under the age of 18. And there are some cases that I put in here for you to look at. One is Roper versus Simmons. The second one is Graham versus Florida. And the last one is Miller versus Alabama and Jackson versus Hobbs, that deal with juvenile cases as it relates to capital punishment. Now, similarly, individuals who are insane or intellectually disabled may not be executed. And we've talked about different defenses and excuses, and several Supreme Court justices have questioned whether it is time for the court to strike the death penalty altogether as unconstitutional. Well, there are a couple other things to finish up, what we call intermediate sanctions or alternative sanctions. And these have become available to judges in many jurisdictions during the last few decades, and these may be imposed in lieu of other more traditional sanctions, and can include things like split sentencing or what we would call shock probation. Some more would be shock parole or shock incarceration, meaning like just put you back in jail for a few days. Mixed sentencing, community service, intensive supervision, or home confinement. A lot of these are different ways that are intermediate sanctions. And I have the definitions for each one of these that you can look at. Split sentencing here again requires a conviction or a convicted offender to serve a brief period of confinement in a local, state, or federal facility, followed by a term of probation. And shock probation is where an offender serves a relatively short period of time in correctional custody and then is released by court order. And shock incarceration would be sentencing option that makes the use of, let's say, a boot camp or something like that. Mixed sentences, again, a sentence that requires a convicted offender to serve, say, weekends in a confinement facility while undergoing probation supervision in the community. So a lot of different things, and this has typically been done for people that work during the week, but they serve their sentence, let's say, on the weekends. Intensive supervision, a form of probation supervision involving frequent face-to-face contacts between the probationary client and probationary officers. And then home confinement, where used to be called house arrest, where you're required to basically stay at home during certain times of the day. And they often here have to wear ankle or arm bracelets that monitor their movements. So this just kind of is a slide that shows you how many people are actually locked up. And take note of the numbers, because there are a lot of people that are in custody. And again, is custody the best way to deal with everything that we've talked about today? So with that being said, we just barely went over our 60-minute time limit, but that's okay because we wanted to get everything in there. Again, don't forget to look at some of these cases. Don't forget to look up the Brock Turner case and compare it to the Corey Beatty case. And don't forget to read the intro that really talked about, a very severe murder case, a very diabolical murder case. And after you read it, think about, well, what would I have sentenced this person to? So take the time to do those things because it really will enhance your learning experience. So with that being said, that's going to conclude our lecture on chapter 14. And hopefully, again, don't forget to read the summary at the end of the chapter. Make sure you look at the definitions at the end of the chapter, or at least look at the definitions page that I posted for you on Canvas. And again, so that will conclude our chapter 14 lecture. Until next time.